There are new requirements for people who are seeking permanent residency in the United States. And to tell us what's different and who will be impacted is immigration attorney at law, Dahlia Walker-Huntington. Hi, Dahlia. Morning.
Good morning, Dahlia. How are you?
I am good. Thank you.
I don't often get to do that.
Two Dahlias. I feel left out. The one Simone feels very left out this morning.
Good morning, Simone. How are you doing?
Hi there. I'm well, thank you.
Dahlia, what are the most important changes applicants need to understand right now?
Well, unfortunately, it's pure chaos that is happening. So the memo was issued on Friday with not a lot of direction as to whether it's going to apply to people who are in the process or new applicants. What's the cutoff date? So we were all taken aback. And really reacted in that fashion. But now over the weekend, us immigration lawyers have had a chance to speak to each other, dissect the memo a little further. And what the memo is saying is that immigration, meaning USCIS, has now tried to overturn what Congress has enacted as a law, that adjustment of status is available to anyone who entered the United States lawfully and has a qualifying relative. So let me give you an example. You got a student visa.
All right.
You went to America. You are eligible to adjust your status. So what this new memo is purporting to say is that you cannot adjust your status. You have to leave and go home to your home country in order to consular process, meaning to go to the embassy with an interview. Now, that poses a lot of problems for people because there is another section of the Immigration Act that says that if you have overstayed for 6 months or more in the United States and you leave, you face a mandatory 3-year bar to coming back. If you've overstayed for a year or more and you leave, you face a mandatory 10-year bar to coming back. The memo makes no mention of that. And so we are advising persons who have pending adjustment of status, do not leave the United States. Call your lawyer this morning. If you don't have a lawyer, get one, because picking up and leaving the U.S. can have some permanent repercussions on you because you are facing a 10-year bar unless you can get a waiver of that 10-year bar.
Yeah, I am not as off here about the U.S. law. There's a Immigration and Nationality Act. I've been hearing people talking about that.
Yes.
Does this conflict with that in any way?
Absolutely. That is the law that was passed by Congress, the Immigration and Nationality Act. Over time, they have updated it. They have taken things out. They've added it. But since 1952, adjustment of status has always been available to persons. In 2000, they changed it to say you have to have entered lawfully. Now, some people who walked across the border from Mexico or stowaway on a ship and are in the U.S. without inspection. What we consider those people, you've never met an immigration officer, you came in, or you met an immigration officer and they released you on your own recognizance. You're not eligible to adjust your status. You must have either been issued a visa or paroled into the United States in order to adjust status. And this is the pathway for the vast majority of people who are here, is to have an immediate relative, a spouse, a parent, if you are under 21, or if you have an adult over 21-year-old son or daughter, they can file to adjust your status if you entered lawfully. And ladies, I can't tell you how many, not just Jamaicans, but people from all over the world who have gained their residency through this process that Congress intended to be a part of the law, the Immigration and Nationality Act.
So Dahlia, if I'm here now, and I'm in the process of applying, or somebody's applying on my behalf for a green card, what are the implications for me?
So if you're in Jamaica, adjustment of status does not apply to you. You
Okay.
do what we call consular processing. So the process goes through the Department of Homeland Security, then the Department of State, and you're scheduled for an interview at the embassy in Kingston. Unfortunately, Jamaica is one of the 75 countries that the U.S. administration placed on a pause in January of this year. So if you go in for the interview now, they're still scheduling interviews and you are to go for your interview. They will check off everything and then give you a paper that says we can't issue you a green card, which is also a visa at this point because of the pause. So continue to process everything as you have before. Part of the reason for the pause is that they're saying Jamaica is one of those countries whose residents use a lot of public charge. I would like to see the statistics on that because Jamaicans, I know, in my 28 years of practice, I've always found a way to find employment. Some have 2 and 3 jobs. You know, that's a joke in America that they put on Jamaicans that we have 2 or 3 jobs. So that rationale, I don't see it applying to Jamaica. But nevertheless, we're telling clients if you're going into the embassy for an interview, make sure you take with you information to show that you either have money in the bank in Jamaica, you have a degree, you have a certificate, you can get a job once you come to America. So that will dispel any notion of the consular officer now or in the future when the new regulations are issued that you are coming to be a public charge on the United States.
There's something that says adjustment of status will happen, but only under extraordinary circumstances.
Right.
Define extraordinary circumstances for me, Dahlia. Like, what would that entail?
I would if I could. I mean, I could if I would. No one knows what that means. And that is actually changing the law that Congress passed in the Immigration and Nationality Act under Section 245. It says nothing about extraordinary circumstances. It only speaks to the manner of entry. If you entered legally and you have a qualifying relative, an American citizen spouse, an American citizen parent, if you're under 21, and an American citizen adult son or daughter, if you are the parent and you entered lawfully, you are eligible to adjust your status. So we are... You know, some of the questions that we heard were, now imagine this memo dropped at 10 a.m. There were already people in different immigration offices across the United States waiting to be interviewed. One of the feedback we received is that the clients were asked, why did you overstay? Why did you remain in the U.S.? Why didn't you leave and go home and consular process? Now, a good immigration attorney would have had those clients prepared with that answer prior to going in, because it's always a question that the immigration officer can ask you, why did you stay? Sometimes people have their spouse in the U.S., they've been going back and forth, and they come up to visit, and, you know, the pangs of love just say, I can't leave this time. I can't leave. I have to stay with my wife or with my husband, and I'm remaining. So those are legitimate answers to questions. Now, what does it mean by extraordinary circumstances? We have no idea because they have not given an example, and that is contrary to the intent of the United States Congress when they passed the Immigration and Nationality Act, Section 245, to say that once you're lawfully in the United States, you can adjust your status.
Dahlia, I want to ask you, like, what is going on? I don't know if I can find another question. I mean, people up there must be panicking now. People who have their processes underway. I can only imagine the calls coming into your office and the other colleagues that you have. What is happening?
Yeah. So there is panic, there is chaos, there is confusion. And so that's why I've said, if you have a lawyer, call a lawyer. Call your lawyer this morning. If you don't have one, call one. There are thousands of people in the process because there's no numerical limit to the amount of people who can apply for adjustment of status in any given year, because it is a benefit to you as having a sponsor who is an American citizen and under the section that you qualify. So people are, there are people who have had children. They've been here for many, many years. They're waiting on those children to turn 21 so that they can file for them. There are husbands and wives who are wondering what is going on. And so the chaos and the confusion continues. But we are encouraging people to please seek representation, attend your interviews. If you have anything in your past that you have not told your attorney about, now is the time to tell them. Because if you go in with this information withheld from the attorney and USCIS knows about it, then you're really opening up yourself to being taken into custody by ICE. So honesty is always the best policy, and having competent representation, because I'm sure today there will be attorneys arguing with immigration officers as they are processing applications, because the officers themselves, they weren't given any guidelines. This broad term of extraordinary circumstances, what does that mean? You cannot insert those terms into a law when Congress itself did not intend for that. And even your own website, as of this morning, does not have those requirements on there. They have on their USCIS website what Congress intended, that family unity, that we don't break up families, we don't take employees away from their employers, we have stability in the economy, is part of the reasons for having 245I.
All right. Thank you.
2:45 a.m. Sorry.
Yeah, thank you so much for illuminating a little bit for us. As you said, the best thing is get an attorney, folks, and they will walk you through the process and see how best they can take it to us.
And don't leave. Please don't buy a ticket and leave right now. Do not do that.
All right. Immigration attorney at law, Dahlia Walker-Huntington.
We're going to hear about a new podcast that's all about community development and nation building. That's after the second edition of News in